Hi everyone! Welcome to my channel. Always remember, ignorance of the law excuses no one. This is Legally Engineered. Okay, so we're done discussing the first mode of extinguishing an obligation, which is by payment. Now we proceed with the second one, which is the loss of the thing due. So covering articles, ano ba yan?
1262 to 1269 of the Civil Code.
But we'll be discussing
the salient provisions only.
the more important one. So please take note.
Kasi na-discuss na natin to dun sa module 3, yung
Yes.
nature and effects of obligations. So we will just focus on the more salient provision. Kagaya ng Article 1265.
Okay. Ano bang sinasabi ng 12?
So whenever the thing is lost in the possession of the debtor, it shall be presumed that the loss was due to his fault unless there is proof to the contrary and without prejudice to the provisions of Article 1165. This presumption does not apply in case of earthquake, flood, storm, or other natural calamity.
So again, this is the presumption of fault in case of loss of thing in possession of the debtor. This article establishes a disputable presumption. So
Yes.
this is not a conclusive presumption of fault whenever the thing to be delivered is lost and the same is in the possession of the debtor. Reasonable itong presumption na to,
Yes.
Attorney Oy.
It is because the debtor who has the custody and care of the thing can easily explain the circumstances of the loss. The creditor has no duty to show that the debtor was at fault. Yun lang. May disputable presumption.
And
To
nabanggit
get
man
fault.
na rin naman na kung kailan yung presumption ay hindi applicable. Mga in case of natural calamities,
Fortuitous events.
the presumption does not apply in that
Yes.
case.
So, let's proceed to Article 1269. The obligation having been extinguished by the loss of the thing, the creditor shall have all the rights of action which the debtor may have against third persons by reason of the loss.
So this pertains to the right of the creditor to proceed against third persons.
So, under Article 1269, the creditor is given the right to proceed against third person responsible for the loss. There is no need for an assignment by the debtor. The rights of action of the debtor are transferred to the creditor from the moment the obligation is extinguished by operation of law to protect the interest of the latter by reason of the loss.
Yes, and that Article 1269 is actually frequently applied in case of insurance. So halimbawa, si S is obliged to deliver to, let's say, B, a specific horse. The horse is lost through the fault of, let's say, a third person, T.
Yes.
So in this case, the obligation of S is extinguished. Again, in this case, the obligation of S is extinguished and he is not liable to B. Such being the case, S would not be interested in going after the third person, T. And the law, however, protects B by giving him the right to bring an action against T to recover the price of the horse with damages. Okay. So, yun lang naman yun, guys. Pag nawala yung thing due.
Oo. Depende mo na kung ano yung nawala. If the specific thing, then the obligation is extinguished.
Pag generic.
And kung ang loss ng specific thing is due to the fault of the debtor, liable for damages. If due to fortuitous event, extinguish at all. If generic naman ang nawala, kahit fortuitous event, kahit fault, may obligation pa rin to deliver the same thing of the same quality and same kind.
Because genius never perishes.
Yes.
So alam niya ng mga estudyante na. Okay, so take note of that.
Yes.
So let's proceed with section 3, the third mode of extinguishing an obligation, which is condonation or remission of debt. So ano ba yung condonation or remission? Ano ba yung definition niya?
So condonation or remission is essentially gratuitous and requires the acceptance by the obligor. It may be made expressly or impliedly.
So it's a form of donation in a way,
Yes.
di ba? So, requisites of condonation or remission are first, again, it must be gratuitous, contrary to onerous, no? So, gratuitous, wala ditong involved na monetary
considerations or any other considerations. Wala
It must be accepted by the obligor. Kailangan ng pagtanggap kasi donation to.
Form of donation.
Form of donation. The parties must have the capacity. Take note, it must not be inefficacious. Okay? And if made expressly, it must comply with the forms of donations. Okay.
So let's have an example kasi nga sabi natin yung condonation or remission is the gratuitous abandonment by the creditor of his right against the debtor. So let's give an example.
Yes. So halimbawa, attorney Uy, si X, may utang siya kay Y in the amount of, let's say, 10,000 pesos.
Yes.
And when X is about to pay Y, si Y, sabi niya kay X, kalimutan mo na yun. Kalimutan mo na yung pagkakautang na yun. Considered as paid. So in that case, attorney Uy, would the obligation of X to pay 10,000 pesos in that case extinguished?
Yes. Kung nandun yung may consent siya, pumayag siya na may extinguish. And it is not in officious. So it is a valid mode of extinguishment, yung remission or condonation of the debt.
Okay. So, in that case, again, extinguish na yung obligation
Yes.
Through the condonation or
remission of the debt.
Debt na meron. Right. Okay, halimbawa naman, under Article 1273,
Yes.
medyo importante din to. Sabi ng Article 1273, the renunciation of the principal debt shall extinguish the accessory obligation.
Yan.
But the waiver of the latter shall leave the former in
In
force.
force.
Na pag-usapan na natin yung importance ng principal at
Accessory obligation.
So kapag nirenounce daw, attorney O, yung principal debt, ano daw mangyayari sa accessory obligation?
It shall extinguish the accessory obligation based on the civil law principle that the accessory follows the principal.
But the converse is not true.
Yes. But kung ang renunciation of the accessory obligation, it does not necessarily follow that the principal debt is likewise extinguished.
I think na-discuss na rin naman natin yan before. But siguro let's just give an example, no? Para lang to reiterate the idea. Halimbawa si debtor, may utang siya na let's say 1,000 pesos kay creditor C. And such debt is guaranteed, no? May guarantor tayo si G. Then the principal debt doon is 1,000 pesos and ang accessory obligation natin is
the guarantee of G.
Halimbawa, nagkaroon ng remission of the debt of D by C. Ano mangyayari doon na attorney Oy?
The remission of the debt by the debt of the debtor by the creditor shall extinguish also the accessory obligation of guarantee.
Si G.
Accessory contract of guarantee of G. But if the guarantee of G is condoned, the obligation of the principal obligation of the debtor shall remain in force.
So, kaya huwag niyong kakalimutan na intindihin, take by heart yung kung ano yung principal at accessory obligation and how are they related to one another. Okay? So, especially pagdating dito sa renunciation, remission and condonation as a form of extinguishment of an obligation.
So, let's proceed to Article 1274. It is presumed that the accessory obligation of pledge has been remitted when the thing pledged after its delivery to the creditor is found in the possession of the debtor or third person who owns the thing. So, Article 1274, it establishes a presumption in case the thing pledged is found in the possession of the debtor.
Halimbawa,
I deliver this ring to my creditor, Mr. Maralik. Kasi nautang ako sa kanya ng 50,000 pesos.
50,000 pesos talaga itong sigsig. Tapos?
Tapos?
So, ibig sabihin, naka-pledge to sa akin?
Oo, parang nakasangla.
Sangla. Collateral.
Oo, naka-collateral. Umutang ako ng 50,000, sabi ni Attorney Baral, siya isangla mo yan.
Baka naman di mo mabayaran to. Scammer ka pala. Inigyan niya ako nito.
If later on, the ring is found in my possession, kung later on, nasa akin
Wala na sa akin.
nasa akin na yung ring, The presumption is that the
Ninakaw
creditor,
niya.
tama. The presumption is that the creditor has agreed to the loan without the pledge. O the simple contract of loan without the accessory contract of pledge. Oo.
So, ang pinipresume daw doon, pumayag ako na pautangan siya ng 50 mil kahit wala
Simple
na yung,
loan. Oo.
yung pledge.
Correct. Right. So, in this case, the creditor may prove that he returned the ring to the debtor upon the latter's request to be delivered back to him.
Hindi, pwede ko namang, that's the presumption. Pwede kong i-rebut yun. Pwede ko namang sabihin na, hindi, kinuha niya lang yan, hinirap niya lang for the meantime, pero ibabalik naman daw niya yun sa akin.
Oo,
So, ibig sabihin, ina-assert ko pa rin na, hindi, may pledge pa rin
Yes.
talaga yan. Okay, so again, it's just a presumption, rebuttable. Now, let's proceed with section 4 as regards the confusion or merger of rights as a mode of extinguishing an obligation.
Yes, so Article 1275, the obligation is extinguished from the time the characters of creditor and debtor are merged in the same person. Yan.
Ano ba yung reason or basis for confusion, attorney?
Yes. So the law treats confusion or merger as a mode of extinguishing obligations because if the debtor is his own creditor, enforcement of the obligation becomes absurd since a person cannot claim payment from himself.
Siya na yung debtor, siya pa rin yung creditor. Siya na naman bida-bida.
Oo,
So,
yun yung confusion or merger. The meeting in one person of the qualities of creditor and debtor with respect to the same obligation.
And when there is confusion of rights, the purposes for which the obligation may have been created are deemed realized. So, just take note of the requisites of confusion.
Yes.
First of which is that
It must take place between the principal debtor and the creditor and it must be complete.
So, siguro bigyan na natin ng example para mas
Yes.
maging malinaw sa atin. Halimbawa, si debtor, may utang siya kay creditor to the amount of 10,000 pesos. For which si debtor nag-execute siya ng negotiable promissory note in favor of the creditor C. Si creditor, in-endorse niya yung note to another person E, who in turn endorsed it to F. Now, F bought goods from the store of the debtor D, the original one.
Debtor.
Instead of paying cash, si F, in-endorse na lang niya yung promissory note to D. Okay. Ano to, negotiable instruments, pero applying extinguishment of obligation.
Pero logic lang yan.
Yes, logic lang din to. Applying extinguishment of obligation, confusion, and merger. Here, si debtor D owes himself. And consequently, his obligation is extinguished by
The
merger.
merger.
Take note na ang nag-issue
Ay,
ng
si D.
promissory note ay si D. Kasi siya yung original
siya yung
na
nag-issue
debtor.
ng promissory note in favor of C. Tapos si C in-issue na kay E, si E in-issue kay F. Until nang kay F, bibili
In-endorse
siya
kay
bibili
tindahan
siya ng
ni D.
tindahan ni D. Yung nag-issue ng check. O, ibig
Promissory
sabihin
note.
nun, it has the effect of extinguishing the obligation by virtue of the merger of the person of the debtor.
Kasi in that case, in the example we've
And the
given,
creditor.
na-comply yung requisites of confusion eh. Una, nag-take place siya between the principal debtor and the creditor. Okay? And complete. It must be complete. Total. No? Hindi pwede, kung partial lang ang nangyari dun, hindi
It will not extinguish the obligation.
Pwede ma-extinguish only to the extent nung amount. Pero in this case, as in total extinguishment because complete naman nga. Okay. How about yung merger, Attorney Uy, 1276?
So, merger, which takes place in the person of the principal debtor or creditor, benefits the guarantor. Confusion, which takes place in the person of any of the latter, does not extinguish the obligation. Ito na naman tayo, yung accessory na naman follows the principal. Yun din yun eh, in essence. Oh.
So,
Diba?
halimbawa, guys, si X, indebted siya to Y in the amount of, let's say, 10,000 pesos.
Yes.
And then, such indebtedness has a guarantor, si W, yung guarantor.
Yes.
Now, if there has been a merger of characters of debtor and creditor in X, in that case, question, would W as a guarantor be freed as well, Attorney Uy?
Yes, the merger of characters, the debtor and creditor in X shall free W as a guarantor.
Why?
Kasi nga si guarantor, siya ay parang accessory party lang. Yung contract of guarantee ni W is merely an accessory obligation. And therefore, kung may merger doon sa principal debtor and creditor, doon sa principal obligation, meron na din, it will benefit the accessory obligation of guarantee.
So therefore, it shall automatically free the
W,
the guarantor from liability.
However, kung kay guarantor naman, merong
merger.
if one of the parties to the merger is a guarantor, it will not extinguish the obligation. Okay? Yan. Ito yung effect of merger in the person of the guarantor. The extinguishment of the accessory obligation does not carry with it that of the principal obligation. Paulit-ulit yan. Consequently, merger which takes place in the person of the guarantor while it extinguishes the guarantee leaves the principal obligation in force.
So for example,
Yes.
dun sa example na binigay natin kanina, halimbawa si creditor, inassign niya yung credit niya to E, who in turn assigns the credit to G, the guarantor, then in that case, the contract of guarantee is extinguished.
However, the debtor's obligation to pay the principal obligation still subsists. The guarantor now, as the new creditor, can demand payment from the original debtor.
Alright, so we're discussing here, Attorney Oy, that confusion actually extinguishes the joint or extinguishes an obligation. How about if the obligation is a joint obligation, Attorney Oy? Would it extinguish as well?
Yes. Confusion does not extinguish a joint obligation except as regards the share corresponding to the creditor or debtor in whom the two characters concur.
Because again, in a joint obligation, there are as many debts as there are debtors, and as many credits as there are creditors. And the debts and or credits being considered distinct and separate from one another. So, hindi talaga ma-extinguish yung buong obligation. It would only extend to the
amount of the joint, kung ano yung utang ng joint, of the concerned joint debtor, or kung ano lang yung do sa joint creditor, yun lang ang ma-extinguish. Not necessarily the whole obligation.
Yes.
Kasi joint.
Yes.
How about confusion in solidary obligation?
So, merger in the person of one of the solidary debtors shall extinguish the entire obligation.
Kanina, dun sa joint, there are yung utang ng bawat joint debtors, they are separate and distinct from each other. Dito sa solidary obligation, there is only one obligation and every debtor is individually responsible for the payment of the whole or entire obligation.
And the only thing to take note here is that he who makes payment may claim reimbursement from his co-debtors for the shares which corresponds to them. So dalawa ito, no? Confusion as regards joint obligation and confusion as regards solidary obligation. Bigyan natin example yung sa joint. Halimbawa, si A, B, and C are jointly liable to, let's say, D in the amount of 9,000 pesos evidenced by a negotiable promissory note.
Yes.
Si D, in-endorse niya yung note to E, who in turn endorsed it to A. Now, would the whole obligation, 9,000 pesos, be deemed extinguished in this case?
So, ang sabi, no, kasi joint obligation. A's share in the obligation is extinguished because of confusion in his person. However, the indebtedness of B and C in the amount of 3,000 pesos each remains because as to them, there is no confusion.
So, consequently, B and C would still be liable to A, and the new creditor, which is to the amount of 3,000 pesos each.
Or 6K.
So, halimbawa naman, in the example we've just given, if the obligation of A, B, and C is solidary, the endorsement to A, again, extinguishes the entire obligation of 9,000 pesos. But A can demand.
Yes, can demand reimbursement
from B
and C.
And the basis of the right of A is not the original obligation, which has been extinguished by the confusion which takes place in his person, but the confusion itself. So that would be the source of his rights. It is as if A paid the entire debt.
Yes.
Okay. Okay. So he can therefore collect the proportionate shares belonging to B and C on an implied contract of reimbursement. Okay, so take note of confusion and merger as a mode of extinguishment of obligation.